Welcome back to The Upper Brand, the show where we unpack the biggest stories, trends, and best practices shaping trademarks, branding, and the broader IP landscape. I'm Rich Assmus, a partner in Mayer Brown's IP Group.
And I'm Kristine Young, also a partner in Mayer Brown's IP Group. Rich, today we're diving into a decision that has trademark practitioners buzzing. It's the Federal Circuit's precedential opinion in Re Brunetti, the F word case, round two. Spoiler alert, the court vacated the TTAB's refusal and sent it back, faulting the board for fuzzy standards on so called failure to function refusals.
Exactly. And if you prosecute marks at the USPTO or litigate them at the TTAB or in district court, this case is now required reading. The Federal Circuit, it didn't just vacate the TTAB's refusal, they also strongly criticized the board for relying on a subjective and case-by-case approach to these failure to function refusals. They did that rather than applying a clear standard in the Federal Circuit's view. So we're going to break down a couple things over the course of this episode. What the Federal Circuit actually said, and just as important, what it didn't say. The current state of the failure to function doctrine, and why the court found that TTAB's reason lacked sufficient clarity. We're going to talk about where this leaves brand owners attempting to register ubiquitous or expressive terms, especially when the PTO's own register is full of inconsistencies. And we're going to go over a checklist for IP lawyers counseling clients post-Brunetti, including how to use the court's demand for coherent rules to your advantage. And as always, a few landmines to avoid when dealing with colorful language and expressive marks. Does that sound good, Kristine?
Let's do it. First, a quick refresher. Back in 2019, the Supreme Court in Iancu v. Brunetti struck down the Lanham Knox bar on immoral or scandalous marks as unconstitutional. The defendant in that case, Eric Brunetti, promptly pivoted and tried to register the F word itself for a range of goods. The USPTO refused, not under Section 2A this time, but under the failure to function doctrine, basically saying the term is too common to indicate a source. The examining attorney and the board then both pointed to the F word's widespread use and its use as an all-purpose word that expresses many different ideas and emotions rather than identifying a single source. The board even called it arguably one of the most expressive words in the English language.
Yeah, so fast forward to 2025 on appeal of the TTAB's decision. And what the Federal Circuit found was that the TTAB had not provided a clear standard for when these all-purpose words can be registered and when they can't. The Federal Circuit highlighted that the PTO has allowed registration for the F word for some products, like snow globes and candies, and in certain phrases, but denied it in this case without any clear explanation. The Federal Circuit instructed the board to clarify its standards and apply them consistently. And I think every practitioner who's been through the trademark office records definitely sees inconsistent application of the rules. The panel did not reject the failure to function doctrine as a whole, but insisted that the TTAB must provide a coherent rule rather than relying on subjective judgment.
So, for practitioners, that means we're in a gray zone. The court acknowledged that the apparent inconsistency of past examining attorneys' decisions with respect to the registration of all purpose word marks is itself strong evidence of the failure to articulate coherent rules. So, if you're counseling a client on a registrability opinion for a single commonly used word, think epic, legend, bestie, or something more colorful, you'll need to grapple with an unpredictable record at the PTO and be ready to challenge the PTO to explain itself.
Okay, so let's hit the headlines of the Federal Circuit opinion, and to us, 3 points stand out. First, the Federal Circuit found that the TTAB failed to provide a clear standard for evaluating these marks. And the court criticized the board for relying on this subjective case-by-case approach, which did not, in the Federal Circuit's view, meet the requirements of the APA. Without that clear and reasoned explanation, the decision couldn't stand. Second main point is that consistency does matter. The panel acknowledged that perfect consistency is difficult, but emphasized that the PTO really needs to consider its own past practices. The court pointed out examples where similar marks were registered for some goods but not others, with no real clear rationale between those. In other words, if one examiner registers a mark, another examiner should not reject a similar one, at least not without a clear explanation. Final point of those 3 is the failure to function doctrine definitely lives on, so don't misread the case in that way. Maybe it's received notice that it's on its last legs, but we'll see. The court agreed that the F word is ubiquitous and could fail to function, but the board still had to build a record, point to evidence, and articulate a rule. The opinion even noted that an increasing number of failure to function refusals in recent years noted that increase and the need for the board to provide rational guidance that is sufficiently explained. I think one of the things that was interesting here is the party trying to get the mark noted that the 100 most common words in the English language were all already registered, and so it does make you wonder why they picked out the F word for unregistrability.
And add Judge Lurie's dissent for completeness, he would have affirmed, writing that anyone living in today's society of degraded language can readily tell the F word does not indicate the source of the proposed trademarked goods and distinguish them from the goods of another. He emphasized that the F word is primarily an explicitive, expressive of a variety of definitions or none at all. And that's a direct quote. It's just that ubiquity that makes it inherently incapable of serving as a source identifier. His approach is the judicial equivalent of "I know it when I see it." Interestingly, but not the law, at least not today.
Great. So, Christine? What do we tell clients about this decision tomorrow morning?
So the Federal Circuit's opinion gives us some new ammunition, and there are a few points to build a quick playbook as to how to deal with this issue. The first step is issue spot early. If the mark is a single dictionary defined word, especially slang, profanity, or some other ubiquitous adjective, flag the failure to function risk at the intake meeting. Also, you need to ask, does the word appear on merchandise as a decorative slogan in the marketplace? So any evidence that consumers treat it as an expressive message rather than a brand, keep an eye out for that type of use. The second step is really that evidence is going to rule the day. Gather proof of source indicating use, such as hang tags, hangers, labels, point of sale displays, and any other materials offered at the point of sale displaying the proposed mark. Secure consumer declarations or survey data to the extent available, tying the term to your client as a brand and not a message. And also, there's some bonus points if you can demonstrate inconsistent USPTO treatment of the same term. So the Federal Circuit specifically noted that the apparent inconsistency of past examining attorneys' decisions is itself strong evidence of the failure to articulate coherent rules. So if that's the case, then use that to your advantage. As a third step, you can draft the application strategically. Consider limiting the goods and services to channels where the mark is used in a trademark sense. For example, for apparel, emphasize label or inner neck tag use rather than front of the shirt display of the mark. You can also attach specimens that scream source indicators, such as the hang tags, packaging, website order pages with with brand placement to increase your chances of success. The fourth step is you should prepare to receive an office action. You likely will get one. Expect a failure to function refusal and have a rebuttal outline prepared before filing. Cite In re Brunetti to demand clarity on the PTO standard. The court made clear that the board must articulate a satisfactory explanation for its action, including a rational connection between the facts found and the choice made. Also, point to analogous registrations, ideally the same words for similar goods, filed in the last 10 years, and ask the examiner to explain any differences. And finally, as a fifth step, you can escalate thoughtfully. If the examining attorney doubles down, weigh in whether to appeal to the TTAB. Try to keep the record clean. Submit all evidence at the USPTO stage unless you want to run headfirst into procedural walls later. From the TTAB to the Federal Circuit, budget 2 to 3 years and set client expectations early. Rich, let me put you on the spot. Suppose a client comes in wanting to register the word bold for a new line of athletic water bottles. They mentioned that bold is a popular word on motivational merchandise and is used on everything from gym bags to hats by various sellers. What do you tell them?
Yeah, so that's a fitting example. Bold is obviously a common motivational term. Be bold. It's definitely used ornamentally in the marketplace as well. So the Federal Circuit's opinion in this case reminds us that the context and frequency of the third-party use, that they matter a lot. So here's how I'd approach it. First, obviously, you're going to check the register. Are there any live registrations for bold for drinkware or similar goods? And if the PTO has allowed similar marks, that's a compelling argument post Brunetti. I definitely look at how that particular client is using the word bold. Is it just printed on the side of the bottle? That might be deemed decorative. But if it's on the label, the hang tag, or packaging in a way that signals a brand, that helps a lot. And we in some cases we get to influence the way that the mark is used. So we would advise the client to invest in distinctive branding and maybe a unique logo or stylized version of bold. The court noted that stylization and placement can impact whether a mark functions as a source indicator. I think in one of our other podcasts about the Penn State case, we talked about where you might look for a mark on a particular item, a particular good. And so that placement can be very important. Finally, with a mark like bold, you have to prepare for potential failure to function refusal and have your evidence ready if you can. Consumer surveys, sometimes they don't have to be specifically commissioned, but the marketing group may have done that in the ordinary course. Declarations, things of that nature, showing in this case that bold is more than just a message, that it's the actual brand.
So, would you advise filing a stylized version in addition to the word mark?
Yeah, we often do that, often recommend filing with a logo or filing with a stylization where we think there's some doubt about the ability to get the word mark itself. Particularly where there's some failure to function hurdle, whether that's descriptiveness or otherwise. Is particularly with that stylization, it's less likely to be viewed as ornamentation. And the Federal Circuit in the case even cited prior cases where the design or stylization made an otherwise unregistrable mark registrable if the features, quote, create an impression on the purchasers separate and apart from the impression made by the words themselves. All right, so let's talk about some of the landmines. These are the pitfalls that we see practitioners hit again and again. And the Brunetti opinion is a reminder that the board is watching for these missteps, and the Federal Circuit itself is ready to call out the PTO for a lack of reasoned decision making. So I think the first issue is these specimens. If your specimen is just a T-shirt with the words screaming across the chest, you should get ready for refusal. The board and the court both emphasize that prominent decorative use is a red flag for failure to function. You definitely don't want to ignore comparable registrations. You really want to consider scouring the register. And if the PTO lets 6 similar marks through, you should definitely cite them. The Federal Circuit in the case said that the PTO must take into account prevailing practice, can't just ignore its own register. You also don't want to assume that the First Amendment is some sort of silver bullet. After the initial decision in the related case over the mark FUCT, applicants might think, I can register anything if they let that one go to the register. But the Federal Circuit has made it clear that failure to function is viewpoint neutral and unaffected by that ruling. You might ask yourself if in the back of the mind of the examiner or the board was the nature of the mark in this case. However, the focus is going to be on whether the mark indicates source, not whether it's offensive. Next lesson is to build a record at the PTO. You can't hope to get that evidence in at the appellate level, so you really need to get that record in front of the examiner and the board. Finally, you don't want to underestimate public backlash. Even if you win the registration, a retailer might balk at stocking goods that they are profanity. I don't know to what extent that this particular applicant has a real business around these marks, but certainly registration isn't the same as market acceptance. And in Judge Lurie's dissent, there was a hint that the F words degraded status in public discourse.
So where does the doctrine go next? Rich, do you see the TTAB tightening its standards or loosening them?
Yeah, so given the posture here where the Federal Circuit sort of said to the TTAB after a presidential opinion, hey, you need to lay this test out more clearly, this is certainly very likely to end up in a second precedential decision that tries to lay out some multi-factor standard for failure to function. What do we think that's going to cover? Well, certainly frequency of third-party use, ornamental use, the context of the applicant's use, the consumer perceptions and what evidence you have of that, and whether or not there's stylization or some other indicator that it's actually acting as a source. The board clearly wants to use this doctrine, so we'd expect it to try to put in these guardrails to satisfy the Federal Circuit. Because the Federal Circuit's message was very clear, the board must provide some rational guidance that's sufficiently explained.
I agree. And I think the prosecution practice will start looking more like acquired distinctiveness fights, lots of declarations, lots of surveys, and other third party evidence.
Great. So if you're listening on your commute, here are 5 quick takeaways. Words in common parlance face a steeper hill at the USPTO, so you should plan accordingly. Evidentiary matters now are very important, as much maybe as the legal argument in failure to function refusals, which we know can be expensive to put together. You definitely want to have a list of comparable registrations at hand. You can use them both as a sword and a shield in prosecution. Always a good idea to file stylized or composite marks as insurance policies against the failure for you to be able to register the word mark, and brace clients for timeline and cost. This matter has been going on for many years. Legal expenses have surely mounted.
Yeah, the Federal Circuit really did practitioners a favor by spotlighting inconsistencies, but the road ahead is anything but simple. The opinion even noted that the increasing number of failure to function refusals in recent years and the lack of clear boundaries for the doctrine. So until the TTAB clarifies its standards, failure to function remains a moving target.
Yeah, and so for trademark lawyers, the mandate's very clear: beef up your evidence, demand clarity from the PTO, and manage client expectations. And don't forget, registration is just one piece of the brand strategy. Sometimes a mark functions, brilliantly in commerce, even without the Circle R.
That's a wrap for today's episode of The Upper Brand. So if you have questions about failure to function refusals, survey strategies, or if you just need to commiserate over yet another office action, drop us a note.
Yeah, in particular, another inconsistent office action. So thanks for tuning in, and until next time, keep building and protecting your upper brand.